Good afternoon, everyone, and welcome. My name is Amanda, and I'm DWDC's program coordinator. Today, I'm joined by my colleagues Taylor and Kat, who are helping to coordinate today's webinar. We're going to start first by acknowledging that the land on which we gather here today is the traditional territory of the Wendat, the Anishinaabe, Haudenosaunee, Métis, and the Mississaugas of the Credit First Nation. These nations continue to experience ongoing colonization and displacement. Today, Toronto is covered under Treaty 13 and the Williams Treaties. Dying with Dignity Canada is mindful of broken treaties that occurred across Turtle Island and recognize our responsibilities as treaty people to engage in a continuous process of truth and reconciliation with all peoples across this land. So I'm thrilled to welcome you today. Through our webinars, we aim to provide you with information and key takeaways, as well as create a space for conversation on end-of-life topics alongside the professionals that know it best. Before I welcome our panel, I'd like to go over a few housekeeping items. Everyone on the call today is muted. However, there will be opportunities for you to submit your questions, and in fact, submit them all throughout today's session. Keep them coming. To do so, please type your questions into the question bar on the Zoom side panel, and we will read it out for you at the end. Try to keep your questions as concise and clear as possible in the interest of time. And of course, while we are going to try to get to as many questions as possible, unfortunately, we may not get to everyone. If you have any outstanding questions or questions that are quite personal in nature, you can email us at support@dyingwithdignity.ca and we will follow up with you. The session will be recorded, so there's no need to take notes. And finally, there's going to be a post-webinar survey that will pop up on your screen after the webinar and gives you the opportunity to share your feedback. We're also accepting registration for an upcoming series of the Death Dialogues program, so you can also submit for that if you're interested. All right, now to introduce our panel who's going to be joining us for today. So of course we have Helen Long. She's Dying with Dignity Canada's CEO. Welcome, Helen. And then we have Chris Jones, who's the Director of Government and Stakeholder Relations. Welcome, Chris. And we've got Kelsey Goforth. She's our Director of Programs. So nice to see everyone. Hi, and welcome. We're going to begin with some of the questions we received from our registrants and then move on to questions submitted live during the session. And like I said, everyone, feel free to keep those questions coming in as they come up to you. All right, so first and foremost, a very big thank you to the over 400 folks that registered for today's session. Credit where credit's due. Our supporters asked a lot of fantastic questions on Maid, advanced care planning, and end-of-life rights. Out of the nearly 150 questions we've received for today's session, about 40% of you asked about Maid, 35% asked about advance requests and the status in Quebec, 10% about Maid and mental illness, and about 5% on advanced care planning. So without further ado, let's go ahead and jump right in with advanced care planning. Kelsey, this question is for you, and it comes from an audience member who wants to know, how do you make sure your family knows your wishes? Do you just tell them or put it in a will, for example? Where can someone start to get their choices put in place?
This is a great question, and I'm glad we're starting with it because it's something that applies to everybody. Anyone over the age of 18 should be thinking about this, documenting their wishes, and having these really important conversations. So it also is a lifelong process. It's something you're doing all the time. You're reassessing every few years. You're looking at how your health changes, and you're continuing to examine what you might want or not want at end of life. So there's a few components involved in this. You're thinking about your values and your beliefs, you're assessing your health status, you're considering different medical scenarios, and you're determining those end-of-life preferences. Then based on all of that exploration, you're documenting those directions and you're choosing the person or people that you want to make those decisions for you in the event that you're no longer capable to do so yourself. We have several resources online that speak to this. We have advanced care planning kits. We have the forms that apply to each province and territory, as well as recorded videos and other resources to help people through this process. One thing, too, that I think we need to clarify, and this person asks about a will. We have to think about when a will comes into effect. The will is looked at after a person has already died. So if a will is in a safe and you're putting end-of-life wishes with that, to be looked at after you're already gone, that's not really going to be very helpful in this context. So that's why we have these resources that are specific to making decisions while you're still alive in an advanced care planning kit and through a directive, it is different than what you would put in a will, which talks to, your estate and financial things and those considerations. So just wanted to clarify that as well.
All right. Thanks, Kelsey. Let's go ahead and move over to advance requests now. So one of the most important issues for Dying with Dignity Canada supporters are advance requests. In fact, about 30% of folks that submitted a question asked about advance requests alone. Many folks share their personal stories, their concerns, and that can really be wrapped up and summarized by this audience question. How do I sign on for Maid in advance of a serious illness? And how can I be assured that I can access Maid when I need it? Helen, you want to start?
Sure. Thanks, Amanda.
Right.
So the short answer to this question, which is the question I think we hear most often, and one that we know both our supporters and the Canadian public is extremely supportive of, over 80% of Canadians support legislation for advance requests. The short answer to this question is there is no legal advance request opportunity in Canada today. There is an exception coming up in Quebec, and I think we'll talk about that a little later on. But right now, there really is no way to have an advance request, whether you have an illness or a diagnosis or not. So we're going to talk a lot more about advance requests, but the short answer is there's no opportunity for advance requests.
All right. Thank you, Helen. We're also going to talk about advance requests and dementia a little bit later as well. As a follow-up question for you, Helen, in that case, what documents could a substitute decision maker rely on to provide someone with Maid in the event that their quality of life is lost or their decision-making capacity is lost, for example?
Yeah, so again, because there's no advance request, there's also no way for your substitute decision maker to decide or to implement Maid for you. You could certainly do all of the advanced care planning work that Kelsey talked about, putting your wishes in place so that in specific situations, people have a better idea of what you would like, but there's no way for a substitute decision maker in any documentation to be responsible for your Maid request.
All right. Thank you so much. We also heard from a number of people who asked about policy changes in Quebec specifically about advance requests and whether those of us across Canada will have the same right in the future. So my next question is for Chris, and it comes from this audience member who asks, could you provide us with an overview of what exactly is happening in Quebec and what opportunities that presents for the rest of Canada?
Sure, thank you. So in June of 2023, Quebec passed an amendment to its End-of-Life Care Act, Bill 11, as it was known. It passed almost unanimously within the Quebec National Assembly, and that allowed for the provision of advance requests. And more recently, the government indicated that it would be making those available and legal to their citizens as of October 30th, 2024. They had hoped in the interim that the federal government would have moved to rectify some outstanding restrictions on advance requests. But in the event that the federal government hasn't done so, Quebec has persisted. As of September 7th this month, the Justice Minister in Quebec instructed the Director of Public Prosecutions in the province not to pursue any doctor, nurse practitioner who provides Maid using an advance request. So as of later this month, it will be an effective legal end-of-life option. There are forms that are currently being put together and that will be made available to the public in Quebec. But of course, remember, you would need to have a permanent domicile in Quebec, and you would need to have a Quebec health insurance card. So there is no opportunity for medical tourism in that sense. You must be a resident of Quebec.
Okay, thank you so much, Chris. Before we move on, just looking at, again, the framework for advance requests in Quebec, is there anything else that comes to mind in terms of requirements or eligibility?
No, the same set of requirements. The main thing, of course, is you will need a diagnosis of a grievous and irremediable condition. So there is that requirement, and the other requirements for Maid being 18 years of age, etc. You will need to have a degenerative condition of some kind. An increasing number of those are neurocognitive disorders, but they are not restricted by any means to those category of illnesses. There are other ones. So yeah, effectively, Quebec will be the first jurisdiction in the country proceeding in this manner. And it reflects a very large societal consensus in that province about this. And followed, I'll just close by saying, it was followed on the heels of a very widespread process of consultation with the residents of Quebec. So this is shared by all political parties, by many people in Quebec. There's a broad consensus for it.
Yeah, thanks, Chris. Talking more about this, can you give us any insights on why Quebec decided to proceed with advance requests, even though Maid is regulated through the federal government? What was, you talked a little bit about already the private members bill, but what was the response from the federal government about advance requests, and what was DWDC's response about this?
Well, essentially, it came from a Quebec provincial government bill, which, as I mentioned, had been the product of extensive public hearings and debate and discussion, a large consensus in the province about the desirability of doing this. And I think as well, it would probably come from a place of the Quebec belief that healthcare is their area of exclusive provincial jurisdiction. And they would cite the abortion arguments as well, that notwithstanding what the feds have done in the past, that these are matters for clinicians and their patients in the province. So Quebec is, I guess, guarding fairly jealously its own prerogatives in this space and moving ahead in a very careful, deliberative manner with a solid piece of legislation that we think, given the other elements, includes like a registry, that should be a template for other provinces, but that's something we can get to in a bit.
Yeah. All right. Thank you. This audience member submitted a question that I think, both you and Helen could weigh in on. And it kind of boils down to this question many, many times again. When do you think advance requests for Maid will become accessible in other provinces? Who would like to start?
Helen, I don't
Have
mind.
you got a crystal ball there, Chris? You could go first.
I wish I did. So that's a matter of conjecture. It's very hard to say at this point. It ties us a little bit in, and I don't want to jump ahead of myself, into Bill C-390, which is a private member's bill introduced in the House of Commons in June of this year, and which is currently at second reading. Now, were that to be, this is in the absence of the feds moving to decriminalize advance requests in the criminal code, which is our preferred outcome and option. But because they have not yet done that, there is a fallback step in the form of this bill. And this would allow any province, it happened to be sponsored by a BQ, a bloc member, but it would allow any province, including Quebec, to set up their own advanced request regime within their own healthcare system. So if this bill were to pass, and it's only at second reading right now, then any province so inclined could do so. But then it would be a matter of, would different provinces want to do that? We have a hunch maybe that Nova Scotia might be a little more open and further ahead of some other provinces, but I don't want to speculate. We'll see what impact Quebec has on the other provinces.
Thanks, Chris. Anything to add before we move on, Helen?
No, I think that, Chris's response is very accurate. And also, it's a product of political will to some extent. So certainly everything that people can do to reach out to their MPP in the case of a province, or MLA, to let them know that this is something you're concerned about, the more of that happens, the better.
All right, thank you. Chris, next question from an audience member here. What are or were the positions for each federal political party when it comes to advance requests?
Sure. So, I've had a lot of meetings with members of parliament on the Hill over the last year and a half, and the parties did, those that were members of the Joint House AMAD committee, the majority view within that committee in the report that was issued in February of 2023 were in favor of advance requests. There's a recommendation in there stating that the government of Canada should legislate advance requests. Now, there were dissenting views taken by the Conservative Party. So if I'm to sum up the positions, I would say a good chunk of the Liberal Party is very much in support of advance requests. The Bloc Québécois is unanimously in support of advance requests. The NDP has been a little bit more cautious, generally favorable, but the debate, which we can talk about later on Maid for mental health issues, caused some conflict there. And so although my meetings with individual members of the NDP would suggest they are supportive, and likewise the Green Party would be supportive. So I would say there is a broad consensus amongst everybody but the Conservatives, with a few exceptions in the Conservative Party as well, the MPs hailing from Quebec, from within that caucus. So that, I guess, in a nutshell, is it.
All right. Thanks, Chris. We're going to switch gears a bit and touch on something you mentioned previously, which was Bill C-390, which is a private member's bill, as we know, proposing an amendment to the criminal code, which Chris, you already talked about. So we already talked about that it is at second reading, but how does that specifically relate to Bill 11 in Quebec?
Well, so I'll just read a really quick line. It's just very quickly what that bill does, C-390. It says, no medical practitioner or nurse practitioner commits culpable homicide if they provide a person with medical assistance in dying in accordance with an appropriate or applicable provincial framework. It's meant to say territorial, but it just for the moment says provincial. So that means that any province, if this bill is passed, any province that enacts such legislation would be able to do so without fear of any kind of sanction under the criminal code. So, but that has yet to pass, and there's a lot of steps to go through. It has to go to committee first, be discussed there. It would then have to come out of committee, be voted on at third reading, make it to the Senate. So that it's not a slam dunk, and we don't know that the life of the present Parliament is a little bit up in the air. So there are a few unknowables there. But it's the first piece of legislation we've had in the House on this. We had a bill in the Senate from Senator Wallin, but that has been stuck for a long time. So this is the first bill in the House of Commons. So,
all right, thank you so much. So this has all been very helpful in understanding the nuances and complexity of medical assistance in dying and advance requests. But I think for a lot of our supporters, the same question comes to mind again and again. You know, what are the main obstacles we will need to overcome in convincing provinces to adopt advance requests? And maybe, Chris, we can start with you again, and then we can touch on Helen if you have anything to add.
Yeah, so I think what we're hoping, and I think it's reasonable, is that as Quebec moves to legalize this medical procedure, this end-of-life procedure, and as other Canadians begin to see that a very progressive, sensible, precautionary kind of government has put this measure in place with the advice of their clinicians, making sure that there's safeguards in place, and that groups such as CAMAP, the Canadian Association of Maid Assessors and Providers, has done that kind of work as well, that's going to provide a little bit of a sense of comfort, a little sense that this can be done in a sensible way. And I think over time, other Canadians are then going to pressure their own respective provincial governments to say, look, that's a set of end-of-life rights that I think I should be entitled to in Saskatchewan, for instance. And, what is my government going to do about that? And I think that pressure, short of the federal government, of course, legislating this, which is our preferred outcome, because the one risk, by the way, Amanda, with the current setup in C-390 is you would end up conceivably having a patchwork of different bills in different provinces with different degrees of access, different qualifying criteria. And I'm not sure that's desirable. I think it would be better to have one stable set of rules. So we will see where we go from here.
Okay, thank you so much. Following up, this audience member was curious about any political or religious groups that would be opposed to advance requests. And then Helen, again, you can touch on this as well. Perhaps this audience member is also curious about, is Dying with Dignity Canada shifting its strategy to advance requests in other provinces? And if so, what those components might be. So again, Chris, if you want to start.
Oh, okay. Well, I think that, the polling, we've just done a poll in BC, but we've done earlier polls that have been national. And I think that they show that the parishioners or the mainstream adherents to different religions in Canada are broadly in support of this. Now, there may be vocal, isolated elements within those churches sometimes in the clergy and the leadership who, for doctrinal reasons, would be opposed. But we find that the ordinary parishioners, not unlike other Canadians, want the same set of end-of-life rights and are eager to have those rights. So we see very elevated levels of support in the amongst most of the major religious denominations in this country, of 75% and up in favor of advance requests. So there is considerable support for it, no matter the background. There are obviously some groups and some ethnic groups that have some different views around some of this, but there's a lot of support for it.
Okay, thanks. Helen, anything to touch on?
Just, I think the last part of your question was about shifting strategy. So I think, you know, our strategy around a change to the criminal code and supporting C390 as a possible second solution will continue. We're going to push hard for advance requests for the rest of this current government, and then we'll see where we are next year and reassess that federal strategy. And then I think, to Chris's point on the province, yeah, we'll start looking at which provinces offer the most opportunity, where a government might be more favorable and supportive of advance requests, where we have better provincial numbers, for example, and we'll just develop those individual provincial strategies, hoping that eventually we can get some kind of a domino effect, that Quebec has it and someone else has it and someone else has it, until everyone has access. But we really, really would like to see a change to the criminal code as the better solution.
Absolutely. All right, thanks to you both. We have just one final question on advance requests, and I'll pose this to you, Helen. This audience member asks, what other jurisdictions around the world currently allow advance requests for Maid, if any?
Yeah, so the advance requests are currently allowed in the Netherlands, Belgium, and Luxembourg, as well as Colombia. Interesting to note that in every country except for the Netherlands, it's actually a requirement that the patient be unconscious when their advance request is fulfilled. So the Netherlands is really the country, I think, that is closest to what we would want to achieve in Canada.
All right. Thank you so much. So before we move on to our next topic, which is going to be general questions about medical assistance in dying, I wanted to cover some questions we received from supporters. So this one here asks, can a substitute decision maker consent to Maid on others' behalf? What about if they disagree with one's decision to receive Maid? Helen, maybe you'd like to touch on this one?
Yeah, so we kind of touched on the first part. There's no role for a substitute decision maker to play in terms of either requesting or consenting, approving someone for Maid. In terms of what someone can do if they disagree, you know, legally there is no role for a substitute decision maker or a family maker or a POA or anyone to play in a Maid decision. It's the choice of the individual, and it's really up to them. That said, there can be really uncomfortable situations created if a family is not in agreement or if there's some conflict around the Maid decision. So we would encourage you to always be including your family in those discussions where you can, to make sure people are aware and have had a chance to speak to you, that you're doing your advanced care planning, so you're kind of setting the stage for what your future direction might be. We know that that is not everyone's preference. Some people would rather keep things quiet, and that's fine. It can just make it a little easier if people are kind of on the same page. And we do find very rarely do we hear about family members who are not supportive. In the rare cases where we hear that, it's usually when they first find out, and given a bit of time, they usually become very supportive of the person concerned. But at the end of the day, they do not have a role to play. There's no way for them to stop you from accessing Maid if you are approved through the regular, the appropriate channels.
All right. Thank you, Helen. Let's move on to the questions now we received about medical assistance in dying in general. So this audience member asks, and I think we've heard this many times, how do I begin the process for medical assistance in dying? This audience member says, I've told my doctor, but I don't have anything in writing. Kelsey, maybe you can tackle this one?
Mm-hmm. So people generally have a couple options when they're at the beginning of the process. One is to speak to their own primary care provider about their wishes to have Maid. It seems from this person's question that they have had a bit of a conversation with their their clinician. And it seems as though that clinician probably isn't actively involved as a MAID assessor or provider, or else they probably would have gotten a little bit more information from them. So there's also care coordination services for each province and territory across the country, most of which don't require a referral from a healthcare provider. Most of the time, the person trying to access MAID can make that call themselves and be connected with a doctor or nurse practitioner in their area who can meet with them and assess them. We do have a list of all of those contacts on our website by province or territory. This person also spoke about not having anything in writing. Helen and Chris already talked about advanced requests and that piece that isn't permitted except for Quebec shortly. So that's been dealt with, but there is also the requirement to have a written request for MAID. This is needed all across the country for anybody accessing MAID as an option. It doesn't necessarily need to be the first step in the process. Again, depends on your province or your territory. So if somebody is looking to move forward, the best bet then is to call the care coordination service in their area to get further directions as to what steps they could take.
All right, thank you. Next question. This audience member asks, can someone access MAID if they are suicidal? And Kelsey, maybe you want to take this one again.
Yeah, sure. So a person can't, and what we have to look back to here is what the requirements are in the law when it comes to MAID eligibility. And one of those requirements that's very clear is that a person does need to have decision-making capacity. So if somebody is in a suicidal state where that decision-making capacity is being clouded by these suicidal thoughts, then they wouldn't be able to access MAID. And this is going back to discussions that have been had for many years about the difference between feeling suicidal and a rational wish to die because of the medical experience that a person is having and the conditions that they have that are causing them suffering. So we do have clinicians all across the country who are extremely experienced as MAID assessors and providers who would be able to consider and determine the difference between the two when they're having those assessments.
All right, thank you so much. Next question. This audience member asks, can you be an organ donor if you receive MAID? Helen, maybe you want to take this one?
Sure. So yes, in some cases you can be an organ donor. It's really done on a case-by-case basis. Whether you have an assisted death or not, there are some rules around organ donation in every province and territory. Typically, for example, it's not permitted after a certain age, or if you have metastatic cancer, you may not be able to be an organ donation. So you would have to look into the rules in your province. Tissue donation usually has fewer limitations, so you may not be able to donate organs, but you may be able to donate tissues. I think if the question is really trying to get at, do the MAID drugs damage organs or somehow prevent organ donation, the answer is no. If you're interested in organ donation and you're also considering MAID, you can just speak to your MAID provider or the organ donation registry in your province or territory to get more information.
All right, thank you. Next question. This one's for Kelsey. This audience member asks, what are the key differences between a track 1 and a track 2 MAID patient?
So just to step it back a little bit and talk about what track 1 and track 2 is referring to, we're really looking at the procedural safeguards that are in place, depending on if somebody's natural death is considered to be reasonably foreseeable, which would be a track 1 scenario, or not reasonably foreseeable, which is track 2. MAID, for those whose natural death isn't reasonably foreseeable, is the newer option. It's been permitted since March 2021, but with the introduction of that track or that option for people, it did introduce some additional safeguards and procedural pieces that a person would need to go through. One thing that I think it's important that we talk about before we get into the details here is what that means, track 1 and track 2, reasonably foreseeable or not. One frequent misunderstanding that we have is that a person who is track 1, reasonably foreseeable natural death, is also considered to have a terminal illness or have 3 months to live or 6 months to live or even a year to live. That's not the case. There's never been a requirement that reasonably foreseeable means terminal. That's not the same thing. So regardless of the track that a person is on, people need to fill out that written request we talked about. They need to be assessed by 2 doctors or nurse practitioners. There are some additional safeguards, though, for people who are track 2. So there's a 90-day assessment period. One of the assessors needs to have expertise in the condition causing suffering, and if they don't, somebody else needs to be brought in to be involved in that assessment. They need to be informed of available and appropriate means to relieve suffering, and the patient and the clinicians need to agree that they've given serious thought to that and have been offered consultations with different services and professionals that may be able to help relieve that suffering. What we have based on the latest data, which is from the Health Canada report in 2022, is that very few people are falling into this track 2 or non-reasonably foreseeable category. Out of the people who received Maid in that year, it was only 3.5% of Maid recipients. So still quite rare, but that's a bit of a breakdown of what those safeguards are looking like.
All right. Thanks, Kelsey. Before we move on, if somebody has a question about whether they're on track 1 or track 2 based on their symptoms or where they would fall if they wanted to make a request for Maid, where could they go to find out that information?
We have some resources on our website that speak a little bit to that. We have, for instance, a webinar with some Maid providers speaking to how they'd assess different sort of profiles we came up with and what track they might be. I think what people need to remember here is that this is all very case by case. We're not going to be able, as non-clinicians, as non-Maid assessors, to tell anybody if they're eligible or not, or if they're track 1 or track 2. This is something that a clinician would determine after a very thorough assessment and a look at that person's full health history and what they're going through now. So somebody who's seriously considering Maid and wanting to pursue it is going to get those questions answered by their Maid provider and assessor.
All right, thank you. Next question, speaking of assessors and providers, this audience member asks, what do you do if you have been found ineligible for Maid? So under the assumption here that this person has completed kind of the first steps, has completed an assessment, and their clinician has found that they do not qualify for Maid, are there any other options this person could take?
So a person can always ask, if they haven't been told already, the reasons why, what part of the eligibility criteria they're not meeting at this point. So that's an option, just to get more information and understand where they stand. People do have the option of asking for another opinion if they'd like to go through the care coordination service again and get connected to someone else. They can certainly ask about that option. Unfortunately, we do hear from people who maybe haven't gone through a full assessment. They may have met with their family doctor and had a very brief conversation, and the doctor kind of said, no, that's not for you. You wouldn't be eligible in this situation. So if that's the case, and maybe your family doctor isn't actively involved in Maid and isn't a Maid assessor, you might consider also reaching out to the care coordination service in your area, because they might be able to actually get you connected with someone who has experienced and can do that full assessment and actually look at the Maid criteria based on their previous expertise.
All right, thank you. For my next question, this audience member was concerned about an interview offered by Jordan Peterson on Maid and the medications that are used to end life by clinicians. So for this question, this audience member asks, what are the medications used by clinicians for medical assistance in dying, and what is the purpose of each medication? And as a follow-up, is Maid painful or is it disturbing to watch, for example? If you could break that down.
Yeah, sure. So there's 3 main medications that are used for Maid in Canada. Midazolam, propofol, and rocuronium are the 3. The first medication is a sedative. The second is going to put the person into a very deep coma. And the third is a neuromuscular blocker that's going to stop the lungs from working and then eventually stop the person's heart from beating as well. So the process is very quick from the first medication to the last. You're looking at that all being done under 10 minutes. And it's leading to a quick death, and it's leading to a peaceful death for both the person who's dying as well as the loved ones who are supporting that person and being with them while they are dying. These medications are not new. They're not new to Maid. They're not new to medicine in general. They've been used in emergency rooms and operating rooms for many, many decades. They're well studied. So a lot of this dialogue out there about drowning and pain and all of these things just isn't based in any sort of reality when it comes to what these medications do and how they work. Unfortunately, what we've seen with interviews like this is we have people who are just very misinformed about Maid in general, but then they're speaking and speaking quite confidently about things that they really don't have any expertise in. And it's unfortunate that we see this information continue to be out there in social media and otherwise.
All right. Thank you so
Amanda,
much.
sorry, can
Yeah,
we maybe
go ahead.
just add for people who are interested in this piece or had further questions, there's both a blog post and a video interview that Kelsey did with Dr. Konya Troughton around this topic, with more details available on our website if people are interested in it.
All right. Thanks for adding that in. Great point, Helen. For many supporters, the fear of losing their cognitive abilities and their quality of life is of great concern. Since an individual must have decision-making capacity to first request Maid, those diagnosed with or concerned about dementia and other capacity-eroding conditions can experience a unique challenge when pursuing a request for Maid. So this audience member asks, and Kelsey, if you could take a stab at this one. This audience member asks, will someone with a dementia diagnosis be able to pre-plan when a certain stage of their disease is reached? So for example, can someone with Parkinsons or Alzheimer's register for Maid early in the course of their disease?
Yes, thank you for the question. This is a big question, and I think one thing we want to clarify first is the discussion about neurocognitive, and we've mentioned it a few times already today. So this does, of course, include things like Alzheimer's, but it also includes conditions like Huntington's disease and Parkinson's disease. Because of a lot that's going on right now in the Maid space, and we're going to talk about this a bit more later on, sometimes these issues get combined and people confuse one thing with another. So some will think that the current ban for Maid in mental disorders or mental illness applies to individuals who have these neurocognitive conditions like a dementia, but that's not the case. So it's important to note that the ban that we currently have is related to conditions that are more considered purely psychiatric in nature. So we're looking at things like post-traumatic stress disorder, for instance. So with that note out of the way, I don't think we'll go into the advanced request discussion again, because Chris and Helen covered that already. Generally speaking, though, when we're thinking about neurocognitive conditions and Maid, eligibility, like we've said before, is very case by case. There's certainly been individuals with a dementia diagnosis or a neurocognitive condition who have been able to access Maid. There's no ban on that, but there are considerations when somebody is going through the Maid process and has one of those conditions. So sometimes a person with dementia will meet with a Maid provider, and they might meet all the criteria. So they've gone, there's no concerns, everything is clearly met. Other times that might not be the case, and a person might meet with a clinician and be told that they're not quite there with one of the eligibility criteria. And if things change, then they might easily meet that criteria, but as of today, they're not quite there. So that's not an uncommon situation. And what happens in those cases is a person will stay in touch with that provider, there'll be open communication with them, and they'll sort of follow them as their illness progresses. So ultimately, again, since this is so case by case, a person who has a neurocognitive condition who is interested in Maid would need to meet with a clinician and would need to share not only what's going on with that main condition, that neurocognitive condition, but they're going to look at all other medical conditions that the person has, any other experiences of decline in capability that person's experiencing. So that's what's so important about these assessments, is that it is looking at the full experience that a person is going through. So we also, because this is a big issue for so many of our supporters, it's a question we get all the time. We have developed a resource, call it a one-pager. It's more like 3 or 4, but it speaks exactly to these questions about MAID and dementia and MAID and capacity eroding conditions. So that's online for anybody to access, as are several recorded webinars with clinicians speaking to this too. And if people have specific questions, please do email us at support@dyingwithdignity.ca, and we're happy to have a conversation.
All right. Thank you so much. For next question here, this audience member is curious, are the extremely elderly eligible for MAID? So I think what this audience member is getting at is that they don't have any sort of qualifying diagnoses or conditions necessarily that would automatically qualify them for MAID, but they're just extremely advanced in age. So somebody that's kind of well beyond the expected lifespan. Could that person be eligible for MAID?
So again, with this question, we need to refer back to the eligibility requirements, and that says clearly that you need to have an illness, disease, or disability that's serious and incurable. You need to be in an advanced state of decline and capability, and you need to have enduring and intolerable physical or psychological suffering. So age alone doesn't make a person eligible. They need to have the criteria that's mentioned there. Of course, as people age, the likelihood that they're going to meet this criteria because they have illnesses, diseases, and disabilities, and they're in an advanced state of decline, and all of these things are met, is of course going to be more likely. But again, this is something where an assessor would meet with the individual and go through everything that they're going through and understand what their day-to-day looks like and how their health has changed over time. So MAID providers can speak to people's eligibility directly and really understand and assess where they're at.
Okay, thank you so much. Let's explore capacity and medical assistance dying a little bit further. So as we've touched on before, Canada's assisted dying law has evolved since its passage in 2015, adding a new track of eligible requesters and the choice to waive their final consent to MAID. And this audience member asked the question, in the event that a patient is approved, what is their status if they become incapacitated or otherwise unable to consent to MAID? And Kelsey, maybe you can answer this one.
So this is going to depend on a few different factors. Final consent, so consent immediately before the clinician administers the MAID medication, is not required in all situations. This changed in March 2021. What is very important for everyone to remember is that what is required is that a person needs to have capacity at the time of their request, and they need to have capacity during their assessments with the clinicians. And Quebec's a different story, which we heard about, but generally speaking, that's how things are across the country. So some people do have this option of a waiver of final consent. And this is only available in certain situations. So a person needs to be assessed and approved for MAID. Their paperwork is done. They've met all the criteria. And in theory, they could have MAID today. But they're saying that they want to live a little bit longer. They're still suffering intolerably, which is why they met the criteria today. But there might be a holiday coming up. There might be an event. They just might want to try to get a little bit more out of their life. So with a waiver, it's tied to a specific date. It's not open-ended. It's naming a date. It's also tied to a specific provider who has agreed to provide MAID for that person in the event that they lose capacity before that specific named date in the document. So there are rules around this. This isn't available for everybody. As I mentioned, there's the being assessed and approved piece, but they also need to be considered track 1, so having a reasonably foreseeable natural death, and they also need to be at risk of capacity loss. So another rule that comes into effect here is that if the person loses capacity and the day has come that they wanted to have MAID, if the clinician is there and the person demonstrates any sort of refusal or resistance to the administration of MAID through words or through gestures, then that clinician can't go forward. So even though the person doesn't have capacity, which is why a waiver would be turned to in that situation, still if there's any indication of refusal, that clinician's unable to move forward. So this is an option for some people. If somebody's going through the Maid process and this hasn't come up yet in their conversation with their assessors, it's certainly something they can raise and ask about and see if it's potentially an option for them.
All right. Thank you. Following up on the waiver of final consent, and you mentioned here about a specific fixed date that's written in the document. This audience member was curious about how long can that, let's call it the provision date. How long can that provision date be deferred into the future after somebody's had that sort of initial approval?
So I think there's two questions there. If the question is specifically about the waiver, there's nothing in the law that specifies that the waiver can only be X amount of weeks or months or however long out from today, for instance. There's nothing that says that officially, but in practice, what we're seeing is that most providers are comfortable with no more than 3 months or 6 months. It's really is a clinical decision. And although the law doesn't really limit that, there is in practice what we're seeing, it's a lot more limited. If the question is more about Maid in general and not tied to any question about the waiver, there's nothing in the law about that. So there's no expiry on somebody's Maid request. Some providers might want certain aspects of the process redone. For instance, they might want you to sign another request form, so there's something a little more recent on file. If a certain number of months have passed since that first form was signed or those first assessments were done. But again, the law doesn't specify that if you are eligible for Maid, you need to have Maid within this many months or weeks or whatever, or else you have to start again. There's nothing specified in the law about that.
All right. Thank you so much, Kelsey. That was a lot of helpful information on Maid. And thank you so much to our audience members for submitting those questions. We're now going to move on and address some of the questions submitted about Maid and mental illness. Many of our supporters were curious about how mental illness and Maid intersect. So let's go ahead and jump in. Helen, this question I think I'll pose to you. And this audience member asks, can an individual apply for Maid under the sole underlying medical condition of a mental illness?
Yeah, so unfortunately, currently, you cannot apply if your sole underlying medical condition is a mental illness. That legislation, although it was written into the legislation in 2021 that individuals whose only condition was a mental illness would be able to apply, that date has been put off several times. There was what we call a sunset clause, so an expiry date that would be removed. Currently, the date is 2027. So as of today, individuals whose only condition is a mental illness will not be able to apply for Maid until March of 2027.
Yeah, thanks. As a follow-up question, can you touch on maybe why the federal government has delayed this multiple times, as you mentioned?
Yeah, I think the official answer would be that the provinces and territories are not prepared to move ahead. When the last extension was provided, there was a standing committee on assisted dying that was doing some work, and one of the things they did was they kind of stated the things that the government needed to do to be prepared to move ahead, and those were to change some of the data that was being collected through the annual reporting, which was done starting in January of 2023, to ensure that there was some kind of education system, which was done by developing a national curriculum through the Canadian Association of Maid Assessors and Providers, and to develop some practice standards and advice to the clinicians that was also completed. So we heard that there were some federal requirements for preparedness. We also heard that those were all met, and yet we've heard that they're not prepared. There are some provinces that have suggested that they need more time, but I think the reality from our perspective is that people shouldn't be discriminated on the basis of their diagnosis. So those individuals with a mental illness should be able to move ahead. They should be able to apply. There was no huge preparation period when Maid became law, when the reasonably foreseeable death requirement was lifted. There's no need for any further preparation, stalling, I would call it, to be done at this point. This law just needs to change.
Yeah, well put. For those who are not aware, there were a few supporter questions that we received about a recent lawsuit that was filed in Ontario about Maid and mental illness. And this audience member is curious, can you share a little bit more about this lawsuit and why it was filed?
Yeah, so, exactly because the law has not moved forward, we felt compelled to file that lawsuit. We worked, with a couple of individuals who had indicated that they would like to file a legal challenge. Dying with Dignity Canada has what's called public interest standing. So we represent all of the individuals that we hear from and people across Canada who may be affected but aren't engaged directly. And I think we just reached a point where it felt like those delays were going to continue. Even though 2027 has been thrown out there as a deadline, I don't think we have any real confidence that that will move ahead. So a lawsuit really just seemed like the only way to move this forward. And that's why we've worked with those individuals who wanted to go down that road, and we've filed that lawsuit.
Yeah, absolutely. And again, in tangent with this question here about the lawsuit, this audience member asks, is it possible that applying for Maid under the sole reason of a mental illness will be available before 2027 as a result of this lawsuit? Do you have any thoughts on that?
Yeah, I mean, it's certainly possible. We expect to be in court in less than a year at this point. So, it certainly is possible. That said, I think there is always the possibility that a favorable decision would be appealed, which would mean further delay. So while it's possible, I think we really have to wait and see what happens. I would not want to, offer false hope to people who are thinking that we're going to be able to get this done really fast, because the law sometimes moves very slowly and change can take longer than we want.
Yeah. Just before we move on, if somebody wants to stay informed or ask more questions about what's going on with the lawsuit, where could they go?
For sure. You can certainly sign up for our updates on our website, or you can just contact us at info@dyingwithdignity.ca. I will say that until we get a little further along, there won't be a lot of updates. We're currently going through kind of what we call the evidentiary process and case management. So there won't be a ton that we can share publicly beyond what we anticipate timing to be. But certainly if you get our updates, we will be keeping people posted of whatever information we do have available.
All right. So thank you so much, Helen, Kelsey, Chris, for your expertise. We're going to move on now to some questions that we received that sort of exist outside of the major topics we talked about today, but no less important. This audience member is a registered nurse from Alberta, and they want to know how they can become more involved with Maid. So Kelsey, I wonder if you could take this one.
Sure. Well, thank you for your interest in being more involved. It's great to have more healthcare providers on board. This person or anyone else is welcome to give us an email at support@dyingwithdignity.ca. The other resource that is wonderful for anyone working in healthcare is CAMAP, the Canadian Association of Maid Assessors and Providers. It's a membership model, but with that membership, you're able to connect with other clinicians and supporters of Maid. They also have several resources just available publicly on their website. So that's a great education option for people as well.
Okay, fantastic. This next question, I think this is a great one as a follow-up to you, Kelsey, as well. This audience member asks, can a non-resident visit Canada to request or receive medical assistance in dying?
So a person who is accessing Maid in Canada has to be able to get healthcare through their province or territory. So that typically means that a person is a Canadian citizen or a permanent resident. If they're neither of those things, then Maid wouldn't be an option.
Okay, thank you. This audience member is asking about our documentary, In My Own Time. They're wondering, is the documentary now public and available for anybody to watch?
Yeah, so that documentary is absolutely available to anyone who wants to watch it. If you haven't seen it, I think it tells a really great story about Maid and end-of-life choice for 3 individuals in Canada. You can find it on our website under the Education and Resources page. Just click on that link and you can watch the whole thing at your convenience.
All right, fantastic. If you haven't seen it already, this is your opportunity. Please go ahead and take a watch. It's fantastic. All right, next audience member question. Maybe Helen, we can pose this one to you. This audience member asks, any plans in Canada for completed life for the elderly, those who don't have a terminal disease or a foreseeable death?
Yeah, so completed life, we hear others in the assisted dying space talk about this. It's kind of defined as someone who feels their life is complete. They're generally older, they've had what they consider a good life. They may be losing friends or loved ones, maybe their circle has become small. They're maybe not at the Maid criteria eligibility point, but they don't feel like they can enjoy all of the things they used to enjoy. Maybe they can no longer travel. So the concept is just that you reach that point and you would like to have an assisted death. So that is not something that we are currently looking at in Canada. It's not something that Dying with Dignity Canada has a formal position on or has done any work around. But I will note it is something that I hear about increasingly, and certainly in other countries we are hearing some conversation about that.
Okay, thank you. For next question here, this audience member asks, and anyone feel free to jump in, is there any support for physicians or nurse practitioners who provide Maid? And they answer as a follow-up here, are doctors morally against it, but provides it anyways? Anybody want to jump in on this one? Helen, would you like to take a step? Oh yeah, go ahead, Kelsey, yeah.
So I mentioned CAMApp. Chris also mentioned CAMApp. That's a great resource for Maid assessors and providers with various different options they offer for connecting people and sharing resources. The second question about clinicians who are morally opposed to Maid, providing Maid, there's no requirement that any clinician, doctor, nurse practitioner must provide Maid. So really the people that are providing Maid are people who believe in Maid as an option and are being patient-centered and are willing to do that work. In some provinces and territories, there is a requirement that a clinician must provide an effective referral to somebody who's going to support their patient if they're not willing to support their patient themselves. We want that. We want people to, at minimum, have that effective referral. We understand that not every clinician wants to actively be a Maid assessor or provider, but we feel very strongly that patients cannot be abandoned and that there has to be this effective referral so that they're not left to try to figure out the process on their own.
All right, thank you. And maybe we can pose this question to you as well, Kelsey. This supporter shares a bit of background about a minor suffering from an untreatable illness and approaching end of life. And so they would like to know what options or resources are available for minors facing end of life.
Well, first of all, I'm very sorry to hear about the experience of that young person and what they're going through. I think, as we know on this call today, you do need to be over the age 18 or older to have Maid in Canada. Just to clarify a little bit about our position on that, we don't agree with a ban based arbitrarily on age. If somebody is 17 and a half dying of a terminal cancer, why do they not have the same rights as somebody who's 18? In many jurisdictions across the country, we do have mature minors who are making decisions that are life or death. They're choosing not to have the chemotherapy that might extend their life. They're refusing other life-saving treatments on a case-by-case basis. And what we feel is that some individuals should have that option for Maid as well, even if they are under the age of 18. We did do some polling on this topic specifically as well in 2023 and found that 71% of people across Canada also support mature minors being able to be considered for Maid in some situations. So a little bit more specific to our our stance on that is that we recommend that if this were to become an option, that the consent of a competent parent would be required for eligible minors who are 12 to 15, and that Maid assessors would be required to consult with the parent if the person is ages 16 or 17. So a little bit about where we're at with that topic. Regarding the question and options or resources for minors, having open conversations with the healthcare team, asking for input from others on the team who maybe haven't been consulted yet, like social workers and ethicists and palliative care providers, is always a great option for people. There's also a specific section on the Canadian Virtual Hospice website that speaks specifically to people under the age of 18 who are facing a serious illness, and that might be a good resource as well for people going through this specific scenario.
All right. Thank you. For next question here, we'll pose this one to you as well, Kelsey. Are there any resources or information you could suggest for someone that wants to become better psychologically prepared for death?
Mm-hmm. So I'm not sure if this person is speaking specifically about someone going through the Maid process. If so, Bridge C14 is a great resource. If somebody is supporting a loved one through Maid Family Support Society provides that support and is working nationally and doing really wonderful work. There's also death doulas that provide support for both people who are dying and those who are supporting a loved one, as do therapists and social workers. So just kind of seeing who's in your area and might be able to help with that. Asking your primary care provider for a list of people that they know who are able to have those conversations and provide some additional support is also an option for people.
All right. Thank you. For our next question here, we have a supporter from the Ottawa area who is eager to get involved with Dying with Dignity Canada and wants to know where they could get started and what they could do to help out. Anybody want to jump in for this one first?
Sure, I think the answer to this is relevant to anyone, not just anyone in Ottawa. You can have a look on our website. There's a section on volunteering. We have jobs posted that are available and also information on the chapters across the country. If you're not in an area that has a chapter, that's okay. We may be able to find you a role working through our national office. So there's that type of work. And then there's also things like sharing your story, if that's something that's of interest to people, or if you want to get involved in more advocacy, certainly our letter writing campaigns. And you can find links to all of those on our website as well.
Okay, thank you so much, Helen. All right, so that's actually all of the registration questions that we had received for today's session, but let's go ahead and work on some of the questions we received during the live session. Thank you, everybody, for joining us and for submitting these questions. Let's go ahead and take a look here. This audience member is curious. Are you required to reapply or redo assessments for Maid if you have multiple conditions or diagnoses, such as having cancer and then being diagnosed with another condition later on? Helen, Kelsey, anybody want to jump in?
Yeah, I mean, I will answer this and hope this is what the person was getting at. And if not, do email us and we're happy to talk more. So if a person goes through the assessment process and they're found eligible, and they meet the criteria, and then they're diagnosed with something else, another cancer or another condition, having those conversations and sharing that with your Maid assessors is important and good that they know that, but and they'll sort of add that information to their notes about your condition. But that doesn't mean that just because you have a new diagnosis on top of your old diagnosis that you'd need to go through the assessment process from the beginning and fill out more forms and do the whole thing again. If somebody is talking about maybe they went through the process and were found ineligible, and then something changed and they got a new diagnosis a couple years later, they can certainly go back through the process and be assessed again. with that new diagnosis or new medical condition as part of the bigger picture now. So do email us though if that doesn't answer your question. We're happy to talk further.
Okay, fantastic. Thank you. For next question, this audience member asks, is DWDC able to provide someone with the support of medical doctors or volunteers in their community? For example, is DWDC able to provide a list of clinicians that can provide Maid or volunteers that offer, grief or bereavement support in their area? What kind of resources are out there? Where could someone start?
Okay.
You want to go? I can go. We don't have lists or provide lists of clinicians. Your first step could always be to contact care coordination in your province or territory, and they'll be able to connect you to the appropriate assessors and providers. In terms of grief supports and volunteers, we don't offer general grief programs, but Kelsey mentioned both Bridge C14 and Maid Family Support Society, which both offer grief and Maid Journey type services. Those links are also on our website, and those are two really great resources.
Okay, thank you. For next question here from an audience member, they ask, if the Conservative Party of Canada were to win the next federal election, could they make changes to the existing Maid legislation?
Maybe I'll take a stab at that.
Sure, Chris, go ahead.
Yes, the answer is they could. They would have to bring in laws. They would have to pass the House of Commons and the Senate and receive royal assent, but it's within the prerogative of a government. Now, there would be some constraints in that there are Supreme Court rulings on some of these things, and that would be a moral constraint to a certain extent. But there are also, and some of the provincial governments have speculated a little bit about this, that if, for instance, the Maid for Mental Disorders alone was brought in, there are some governments that have suggested that they would invoke the notwithstanding clause to opt out and ensure that their clinicians were not providing those services. So it's very hard to know, and there's a lot of speculation about this. We kind of would have, I think I would have the view that the consensus in support of Maid Track 1 is very strong, and arguably it is as well for Maid Track 2. But we do, for what it's worth, we know that at final reading in 2021 that most of the Conservative caucus voted against C7. So it is hard to predict what they would do in the event they came to power with a majority. But I think we could safely say that there would be no further expansion of Maid for the time being. I think, Helen, I don't know if you would want to comment on that, but I mean, that's kind of where I'm landing.
Yeah, I mean, I would agree. I think, there has been no statement or nothing publicly said about either Track 1 or Track 2 Maid legislation. The Conservatives and Pierre Poilievre specifically is on record as saying that they will rewrite the mental illness legislation if they come to power. So, I think that's something we want to be aware of, and that's part of the reason now that a lawsuit does make some sense. But I think the existing Maid laws are firmly grounded and have been in place for, a long period of time. So I think based just on public support, we would be, cautiously optimistic that things will continue in the same vein.
Yeah. Okay. Thank you so much. Next question. This audience member is asking about the other lawsuit filed in British Columbia, asking about the court challenge for institutional religious obstructions, and asking, are there any updates? And maybe if someone could also provide an overview of what's going on with that challenge, and then an update after, if anybody'd like to take a stab at that.
Okay, so we have two cases. We have the mental illness as a sole underlying condition, which is what we call a charter challenge. happening in Ontario. And we talked about that a bit earlier, basically working through the evidentiary pieces, hoping to be to court in the next 6 months or so. Next 9 months or so. In terms of the BC case, so the BC case is around what we call a forced transfer from a religious facility. So basically the premise of the case is that institutions, that's bricks and mortar building, do not have the same conscience rights that clinicians have. Clinicians have conscience rights not to perform procedures that they don't want to perform for conscious reasons. We do not believe buildings have the same rights. So again, that's a constitutional challenge, suggesting that the Constitution does not give buildings the right to deny medical care. And I think most people are probably aware of the Sam O'Neill story. Sam was a young woman who ended up in St. Paul's in Vancouver and was not able to access Maid and went through a very undignified, painful, very sad and distressing transfer to have her assisted death. So that case is kind of in the same place. Responses have been received from the three parties involved, the three defendants, and we're just working through the back of the scenes next steps. And again, hoping to get to court in that one maybe sometime in the spring. But you know, a lot of this is out of our control. So there's a bit of a back and forth process, and we're just working through that.
Okay. Thank you so much, Tip, for that question to the audience member here. We've just got a few minutes here before we'll end the session. So let's just take a look here. This audience member is curious, is chronic pain considered a condition that could qualify somebody for Maid? Kelsey, maybe you can take a stab at this?
So with anything related to Maid, we don't have a list of these are the conditions that mean someone gets Maid and these are the ones that don't, with the exception of psychiatric conditions that we've talked about already. So have people with chronic pain conditions been able to access Maid? Yes. Again, to determine eligibility, a person would need to have a fulsome assessment with a doctor or nurse practitioner who's looking at the full picture of everything they're going through. But there's no blanket ban on chronic pain. But there's also no list of these are the yes conditions and these are the no conditions.
Okay, thank you. Next question here. Can you put a request for Maid into a living will or an advanced care directive in this case? We talked a little bit about how advanced requests were not accessible across Canada right now, but maybe we can touch on what is the effect if you put a request for Maid in your advanced care directive? Can it be enforced? Does it have any impact on somebody's end of life care? Helen, would you like to take that?
Well, yeah, I think that's maybe two separate questions. So, well, I guess the answer again is because we don't have advance request legislation, there's no reason to believe that, you know, that would not do anything for you today. In the event the law changes, is it possible that if you've written something in your living will or in your advanced care directive that you could receive Maid down the road? It's possible. Certainly, there's no harm in doing so. Kelsey, correct me if I'm wrong. Is there one place that doesn't allow you to refer to Maid in your?
I don't know, not to my knowledge.
I might have made that up. So there's nothing, you're not causing any problem by referencing it, but we have no way of knowing whether it would be enforced down the road because we have no way of knowing whether you would meet the criteria that would be laid out. So if you are going through the advanced care process, there is some information, small bit of information on that in that kit, which you can download from our website.
Okay. All right, so that is all the time we have for today. Thank you so much to everybody that submitted their questions. Thank you so much to my lovely team members here for being on the panel today. And thanks to the generosity of our supporters. We can provide webinars like this and all of our other quality and compassionate services 100% free of charge to people across Canada, their loved ones, and their healthcare providers. So we ask that you please consider paying it forward and empowering us to continue the work we do by making a donation today at the link that we're going to include in the chat box. Just want to say thank you so much for your support, for joining us today, for submitting your questions. We certainly couldn't do this without you. Anybody else want to sign us off here?
Nope. Thanks to everyone for coming. We appreciate having you here.
All right. So that's all the time we have for today. Have a wonderful afternoon and take care, everyone. Bye-bye.